Hello to everyone. So this is my second video lecture on Hindu Adoption and Maintenance Act 1956. In today's video lecture we shall focus on two important sections of this act, section 9 and section 10. So here's myself, Dr. Mrs. Sonali Gaikwad, Assistant Professor, DGP Dayanand Law College, Sholapur. So before we begin with a small introduction on today's video lecture. The son under Hindu law has been assigned utmost importance in the Hindu Dharma Shastra. Male issue was treated as necessary for protecting the deceased parents from the sufferings of the hell and to perform their funeral obligations. Hindu law recognizes basically three kinds of son, namely the legitimate, illegitimate and adopted son. Now what is adoption? According to Manu, adoption is the taking of a son as a substitute for the failure of male issue. Thus, it is a transplantation of a son from one family in which he is born to another family where he is given by the natural parents by way of gift. Adoption is a legally recognized mode of affiliation as the son of a person of one who in fact was not his son. On adoption, ties of the son with his old family are severed and he is taken being born in a new family, acquiring rights, duties and status in the new family. Now in present scenario, the Hindu Adoption and Maintenance Act 1956 has completely codified the law of adoption and has materially modified it in correspondence to the needs of dynamism of Hindu society. Therefore, every adoption shall be made in conformity with this act and any contravention of the provisions of this act shall be void. So moving on to our next slide, which explains about main objectives of adoption. So if you see, basically there are two modes of adoption recognized under Hindu law. One is religious and other is secular. Religious objective is to secure performance of one's funeral rites, whereas secular objective is to preserve the continuance of one's lineage. And same view was laid down under Inder Sharma versus Kartar Singh in the year 1966. Now let's see some of the important definitions which we have already discussed in my first video lecture on the same act. But to revise, section 3 of this act provides for three basic important definitions. That is, one is custom and usage, second is maintenance and third is minor. So coming up to the next slide, section 9, which gives the explanation of persons capable of giving in adoption. So let's see what does subsection 1 says. No person except the father or the mother or the guardian of the child shall have the capacity to give in adoption. So there it is, three categories are recognized. First is father, second is mother and the third is the guardian. Subsection 2 says that subject to the provisions of subsection 3 and subsection 4, that is coming subsections, which deals with rights of mother, and subsection 4 deals with rights of the guardians. The father if alive, so very important to note that the father if alive alone shall have the right to give in adoption, but such right shall not be exercised unless he takes the consent of the mother. But consent of the mother may not be required if she has completely and finally renounced the world, or has ceased to be a Hindu by conversion to another religion, or has been declared by the court of competent jurisdiction to be of unsound mind. So moving on to the other subsections, subsection 3 says the mother may give the child in adoption if the father is dead, or has completely and finally renounced the world, or has ceased to be a Hindu by religion, or has been declared by the court of competent jurisdiction to be of unsound mind. Unsound mind means The person who is not able to understand, or who cannot understand what is right and wrong, a person who is not able to know the consequences of the acts which are committed by him. What does subsection 4 says that now this subsection deals with the rights of guardian. The term guardian includes a testamentary guardian, that is a guardian who may be appointed by the will of the father or mother, or a guardian appointed or declared by the court. A guardian cannot give a child in adoption without the prior permission of the court. A guardian has a capacity to give the child in adoption under the following circumstances. Number 1, if both the parents of the child are dead. Number 2, if the parents have finally and completely renounced the world, or if the parents have been declared by the court of competent jurisdiction to be of unsound mind. Number 4, if the parentage of the child is known, and it also specifies that if the parents have abandoned the child. That is for example in cases of the foundlings, or it may be include a refugee child. Next is subsection 5, which deals with or which says that before granting permission to the guardian under subsection 4, the court shall be satisfied that the adoption is for the welfare of the child. So this is very important. The court will give due regards to know the facts whether the adoption is for the welfare of the child or not. So due consideration being for this purpose given to the wishes of the child, having regards to the age and understanding of the child, and that the applicant for permission has not received or agreed to receive, and that no person has made or given or agreed to make or give to the applicant any payment or reward in consideration of the adoption except such as the court may sanction. Okay, so next, section 10, what does it say? Who can be adopted? So number 1, subsection 1 of section 10 says that he or she should be a Hindu. So the child who is to be adopted, he or she, whether it is a boy or a girl, should be a Hindu. Second, he or she has not been already adopted. He or she has not been married, unless there is a custom or usage applicable to the parties, that is, one who gives and the other one who takes, which permits persons who are married being taken in adoption. And finally, he or she has not completed the age of 15 years unless there is a custom or usage applicable to the parties which permits persons who have completed the age of 15 years being taken in adoption. So next slide sees about the concept of adoption of an orphan, whether orphan children can be taken. The answer is yes, orphan children can be taken in adoption, but with the previous permission of the court, which is claimed by the guardian of that orphans. So some of the cases in which adoptions were considered as legal. So first is Kodippa Shirke versus Kannappam in the year 1990, which states that it was held that where customs or tradition allow there a person above the age of 15 years or married persons, then such persons can be adopted. Second case deals with Dev Gonda versus Sham Gundad, which was decided in the year 1992, in which the Bombay High Court held that any infant can also be adopted. Further, an orphan found child or abandoned child can also be adopted. So we have seen these two important sections in this today's video lecture. So for now, I would say thank you for watching this video tutorial, for this video lecture. So in my next video lecture, we shall discuss about some further sections. So till then, stay tuned and stay safe, stay healthy. Thank you very much.